Welcome to Navigating Consumer and Family Law Challenges. Insights from SoCal's trusted attorneys.
Hello and welcome to Navigating Consumer and Family Law Challenges. Insights from SoCal's trusted attorneys with Amanda Hill. With a focus on family law, Amanda offers helpful, caring, and professional legal services and advice. I am your host, Kevin Rosenquist, and today's episode is Navigating New Waters, Understanding Post-Divorce Modifications. Amanda, welcome back. Good to see you.
Hi, Kevin. Thanks for having me.
So let's start with, if you could just explain what a post-divorce modification is and sort of the typical situations that might lead someone to seek one after their divorce is finalized.
Sure. So the most common scenarios are modifications on parenting plans or custody and visitation orders. The other common situation is there's a change in financial situation. So somebody needs to post-divorce go and change the child support or spousal support orders because there's been a change in circumstance. Usually those are the two main categories. Other than that, post-judgment, the only thing I usually see is somebody's not complying with the judgment or the orders that were made, and you have to go back in and try to get remedies to enforce them.
Are there legal criteria that must be met for a court to consider a modification request?
Yes, and it does depend on what type of request you're making. So to start off by addressing the custody issues, if you're making a custody modification request, it really depends on what the language of the judgment says. So without getting too much into the nitty-gritty, there's something called the Montenegro orders that can be made. And if the judgment mentions that this is a quote unquote Montenegro order, which is just in reference to a Supreme Court California case, it means that this is a permanent order. And the only way to change those orders is to show that there's been a change in circumstance to warrant a change in the orders. If that language, however, is not in there, then you really just have to show that the request that you're making is in the best interest of the children. So it just depends on what the threshold is, depending on if that language is in the judgment of the divorce. If it's a child support motion that you're trying to modify child support orders, then really the only threshold is, has there been a financial change in circumstance? Has somebody changed jobs, lost a job, reduced in how much they're making, or maybe they're not making overtime anymore, whatever the case may be, or maybe they have more time with their children and so they should be receiving more child support as a result because somebody said that they were going to do a certain amount of parenting time and then in actuality, after several months, it just didn't happen. And so you want the support orders to be modified to reflect that.
The key point you brought up, which I think is very important, is best interest of the child, correct?
Yeah, that's always what the court's going to look at. Even on child support orders, interestingly enough, the court's going to make sure that if it makes sense for the child support orders to be modified, they're going to do it because ultimately the child support is for the support of the child.
Yeah, I think that's something that people have to always remember, that it really does boil, when there's kids involved, obviously it really does boil down to what is best for the kids in these situations.
Yes. I don't think we addressed it yet, so I will briefly mention also on the spousal support issue. Some people think that after a divorce judgment is entered and maybe their ex-spouse is now making a lot more money or they got a big promotion, that they can then benefit from that. That's in general not true unless there's been a change in circumstance for the person receiving the support. So God forbid they become disabled or they, lost their job, then in that circumstance, that could warrant a change in the support that they may be asking for. It does get more complicated than that, but I will stick to the basics today. But in general, though, you can't you don't get rewarded or so to speak, or get more support if now your ex-spouse is making more money in the spousal support category. With child support, you can go in and ask for a modification if that is the case.
That makes sense. That seems right to me. Like, to not make a modification just because, if there's no kids involved, just because somebody's making more money on one side. What about significant life changes such as new marriage or something like that? Are there other examples of when a modification might be justified?
Yeah, a lot of people ask this question, so I'm glad you're asking it. I have people ask me all the time, like, hey, they're now living with somebody else. that other person, is contributing to their household expenses. That's not fair. I haven't moved on. So can I get more support from that person now? Again, on spousal support in general, no. If, however, the difference is if you're the recipient of spousal support and you now are living with somebody else, the presumption is that your need for support has been reduced. And that would warrant the person paying the support to be able to go back to court and say, hey, their need has been reduced because somebody else is helping contribute to those expenses. So can we relook at what the spousal support order should be? Obviously, too, if somebody gets remarried and there's spousal support orders in place, they automatically terminate. So as soon as you get remarried, you're no longer allowed to get spousal support from the other spouse.
A lot of times people, they're in partnerships, but they don't get married necessarily through the court. Are there other situations where you could say, hey, this person, they've been together for X amount of years. Clearly they're in a real relationship or of sorts, or does it have to be that actual marriage certificate?
Well, when it comes to spousal support, there's a presumption that if they're living together and sharing in their expenses, their need has been reduced. So you can go back to
Mhm.
court to adjust it, but it's not an automatic termination as if they're legally binding married. Because the public policy is if you're married, you've now bound yourself through a legal contract, right? I know a lot of people don't like to think about marriage that way, but it really is. It's a legal contract.
It is, yeah. When you get down to it, yeah, yeah. All right, that's all. Is that all it is? Should I say something to my wife? Hey, this is just a legal contract. I don't really know why you're.
I don't know how that's going to go over.
Okay.
But yeah, so I'm going to say no on that one.
Okay. All right. This is why I have you as my life coach. What's the general process if someone wants to file for a post-divorce modification? Is there certain documents, evidence that they should have prepared before they do that?
Yes, you definitely want to make sure that whatever evidence you're going to plan to submit to support why you're requesting what you're requesting to be modified, that you have all the documented evidence. So, for example, let's say you have gotten terminated from your job. You can't just necessarily say, I got terminated from my job. Make sure you have the letter of termination to show proof you no longer work there. I would always recommend in those types of situations, make sure it documents why you left because time and time again, the other side, they're not going to trust you, right? You're their ex-spouse. They're going to say, "Oh, well, you quit." Or you caused yourself to get fired because you just were so sick of paying me support, right? So you always want to make sure that you get a detailed letter as to the terms, or maybe you got laid off, right? So then maybe are you getting unemployment benefits? Are you going to be on disability because you had a surgery? Make sure all that documentation is gathered before filing that motion so you have it all ready to go.
Seems like a very drastic way of getting out of spousal support is to quit your job. Seems like that would cause a lot of other problems.
Kevin, you would be very, very surprised the amount of times I've had to have that conversation because people are just so, upset or irritated or, want to get back at their ex-spouse. The good thing though is on that topic, the California courts have something to deal with that. So if it is found that you purposely quit your job, then what will happen is you can claim to the court that they should be imputed that income, regardless of whether they're actually working there or not, if you can show proof that they purposely did that.
All right. So once this modification is granted, does it go into effect right away? Is there a timeline?
Yeah, so once you file the motion, oftentimes you're not going to get a court date for several weeks, most of the time several months later. But the effective date, if it's a support issue, can be made retroactive from the month following when you file. So for example purposes, if you file it in March, you would get it effective April 1 forward, even if you don't have a hearing until July. That's on support issues. On custody, obviously, it's a little bit more different. I mean, it's a little different because the current custody orders are going to remain in place until a judge modifies them.
In a situation where maybe one of the other party fails to comply with the modified terms, what steps can the other person take to force them or make them comply?
Well, when it comes to child support, there is the Department of Child Support Services that have resources to help people who are having a hard time getting the other person to comply. They can have a wage garnishment issued to their employer. If they're self-employed, they can get their bank accounts levied, their tax returns intercepted. So there's definitely some ramifications there. Passports can be withheld, renewals. can be withheld. So they don't mess around when it comes to child support,
Yeah.
which is obviously good, right? We don't want people to not support the children that they have. If it's something other than that, though, sometimes you want to consult with a judgment attorney who solely works on collections issues. So sometimes they'll say, "Hey, I'll take a percentage of whatever I'm able to collect," and then they're kind of like little PIs that go out there and they figure out creative solutions on getting somebody to comply. The other example I would give is if somebody's supposed to be, this one comes up a lot actually, where they're supposed to refinance the marital home into one party's name because they're keeping it, because the other party doesn't want to be financially obligated to that because they're not keeping it, right? But they don't do it, especially with today's interest rates being as crazy as they are, and certainly not what they were when people maybe first took out the loan. They're going to delay, delay, delay. And if that happens, then you can file what's called a sanctions motion against them for not complying with that order. And if they still don't enforce it or they still don't comply, so to speak, then you can ask for an alizer to be appointed, which is just a fancy word of saying you want the judge's clerk to sign the documents for you on your behalf because the other side is just not complying. That's like the worst and final step, but it is available if it becomes necessary.
So we've talked about financial modifications. What about visitation or how custody is balanced? How do modifications work as far as that goes?
You know, the court's always going to look at what is the history of these parties and with these children. So even without whatever the threshold is, whether it's a Montenegro order has been made or not, the court's going to say, hey, does it make sense to modify it? Because they want to look at how is this going to impact the child's life? Is this a very dramatic change of what has been exercised and what has been the status quo for many months now or even years? And how is this change that's being requested going to impact them? So, for
Mhm.
example, there's cases where somebody, let's say they're school aged kids and they have homework that needs to be completed, but one parent is clearly stepping up more than the other. And maybe now they're missing assignments, or maybe they're tardy to school consistently, and you can show that pattern of behavior. That's going to be a motion that the court would definitely consider because schooling is really important for the court. They want to be able to set these kids up for success in the future. So if one parent's clearly doing most of the labor on that and you can show proof and documentation of that, that would be something that the court would consider in changing, for example, a 50-50 schedule to maybe one parent being the primary parent during the school week and one on the weekends.
Do you get a fair amount of requests for modifications from clients?
Yes, I do. The hope is always that, after divorce, things have settled down, simmered down, emotions are a little bit less heightened, but that's not always the case. Sometimes new significant others can either help or hinder that issue. Really depends. I know we talked about that in a past episode, but so that does depend. I will say the biggest one that I've seen recently is requests to move because
Yeah.
people are moving out of the area because of the cost of living. But you can't just do that without a court order or a written agreement. So that does become a contested issue.
What do you get some strange requests sometimes for modifications where you're just like, yeah, you can't do that.
Yes, and sometimes the hardest part about being an attorney and making sure that, you're transparent and clear with people who call in and who are looking for guidance is you got to tell them the good, the bad, and the ugly, right? Even
Mhm.
if it doesn't and it clearly doesn't make sense. And I'm definitely of the mindset that I'm not going to take every case that walks through the door if it doesn't make sense, because ultimately, it's also my reputation on the line. I'm not going to go in and argue something that doesn't make sense or is not supported by the law. But in addition, you certainly don't want to file a motion that's not supported by anything because you can also be sanctioned by the court for being over litigious and maybe asking for something that is either would be considered the waste of the court's time or would be clearly harassment to the other party.
We've talked about this on this show before, but you're like not a certified therapist, but you kind of have to be part therapist in what you do.
Yes. I would say earlier on in my practice, I had a harder time differentiating that. And sometimes I felt like that was maybe more of my time was being spent that way. But I've
Yeah.
gotten very good I have a very thorough list of referral sources for clients. And I always remind them of those referral sources if they need it. because, that's really not the role of an attorney. But certainly, empathy and patience is clearly needed in this role for sure.
Yeah, and you can tell you're an empathetic person. I mean, you can't do what you do without being an empathetic person. So it makes sense that at first you might have taken on a little too much of that therapist role and then learned how to delegate that out, if you will, and stay in your lane and make sure that you're giving your clients what they need.
Yes, yes. Definitely always that balance.
Balance. Exactly. I mean, is it difficult to ensure that their interests are being effectively represented sometimes when it comes to these post-divorce modifications?
I don't think so. I mean, I will say I have repeat clients, right? I have clients
Yeah.
that I've helped them with their divorce, and then they come back to me and either they're getting a prenup with their new spouse, or something has happened and that they need to modify whatever the current orders are on custody or support or what have you. And so because of that, we already have that rapport built and it's easy. I will say there are some people though that unfortunately, maybe it wouldn't make sense to come back, to continue that relationship post judgment. I would say the vast majority though are clients that, they even refer their friends or families, right? Because there's a sense of comfort. That's what we really pride ourselves on, is not feeling so stuffy, right? Being a
Mhm.
law firm that provides guidance and legal expertise, but also is not approachable. I mean, or is approachable, I should say, because you certainly don't want to feel like people can't feel comfortable asking you, various serious but personal questions, especially when you're dealing with people's families.
Yeah, it's very sensitive. A lot of things are sensitive, but with family law, there's just a different vibe there for sure.
Yes, exactly.
Yeah. All right. Well, thanks for joining us on Navigating Consumer and Family Law Challenges, Insights from SoCal's Trusted Attorney with Amanda Hill. To connect with Amanda and her firm, visit kandhlawgroup.com. And don't forget to like and subscribe to our channel. Amanda, so great having you here. Looking forward to chatting with you again.
Thank you.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.